I was standing in my kitchen in rural Jefferson County, Colorado, pouring my second cup of coffee when I heard the rumble of heavy machinery coming up my driveway. It was barely past 7 in the morning on a Saturday in March, and I had not ordered any work to be done on my property. The sound got louder, closer, and more aggressive as I walked toward my front window. What I saw made my blood run cold. A massive bulldozer was tearing across my front acreage, blade down, ripping through the wildflower meadow I had spent 3 years cultivating. Behind it, 2 smaller tractors followed, their drivers seemingly oblivious to the destruction they were causing. My heart hammered in my chest as I watched soil and plants being torn apart, the careful ecosystem I had nurtured being obliterated in seconds. I bolted out my front door, still in my pajama pants and a faded Denver Broncos t-shirt, waving my arms and shouting. The noise from the machines drowned out my voice completely. I ran toward the bulldozer, getting close enough that the operator finally noticed me. He killed the engine, and the sudden silence was almost as shocking as the noise had been. "What the hell are you doing to my property?" I yelled, my voice hoarse with anger and shock. The operator, a weathered man in his 50s with a cigarette dangling from his lips, looked down at me with mild annoyance. "Got a work order from the HOA, buddy. We're clearing this land for the Community Beautification Project." Community Beautification Project? I could barely process what he was saying. "This is my private property. I never authorized any work. Get off my land right now." The man pulled out a crumpled piece of paper from his shirt pocket and squinted at it. "Says here we're supposed to clear Lot 17 in the Meadowbrook Estates subdivision. That's this address, isn't it?" "I don't care what your paperwork says," I shot back. "You're destroying my property without permission. This is trespassing, and you need to leave immediately before I call the police." The other 2 operators had shut down their machines and were walking over. One of them, a younger guy with a buzz cut, shrugged. "Look, man, we just go where we're told. You got a problem? Take it up with the HOA. We're contracted to do the work." "I am taking it up with you because you are currently on my property destroying it," I said, trying to keep my voice level despite the rage building inside me. "Turn those machines around and get out, now." The first operator sighed and pulled out his phone. "Let me call the supervisor. This is above my pay grade." While he made his call, I surveyed the damage. They had torn up nearly a 1/4 acre of my carefully maintained wildflower meadow. Native columbines, lupins, and Indian paintbrush that had taken years to establish were now just churned dirt and broken stems. The topsoil I had enriched with compost was mixed with subsoil in ugly brown piles. My hands were shaking. The operator finished his call and looked at me apologetically. "Boss says to continue working. Says the HOA president, a Mrs. Kimberly Anderson, personally authorized this job and we have a contract." "I don't care if the governor authorized it," I said, pulling out my own phone. "This is private property. I am the owner, and I am explicitly telling you to leave. If you don't, I'm calling the sheriff's department right now." The 3 men exchanged glances. The older operator shrugged again. "Your call, but we got a job to do. Boss is on his way here anyway to sort this out." I dialed 911, my hands still trembling with adrenaline. When the dispatcher answered, I explained the situation as calmly as I could. She told me a deputy would be there within 20 minutes. I thanked her and turned back to the crew. "Deputy's on the way. Nobody touches those machines until this is sorted out." The men seemed content enough to stand around and wait. The younger one lit up a cigarette, and they started talking among themselves about a Rockies game from the night before. I walked back toward my house, documenting everything with my phone camera. I took photos of the destroyed meadow, the machines, the license plates on the trucks that had brought them, and the workers themselves. I filmed video of the extent of the damage, making sure to narrate what I was seeing with dates and times. My neighbor, Tom Henderson, came walking across the property line that separated our 5-acre parcels. Tom was in his 70s, a retired engineer who had lived in the area since before the HOA was even established. He had warned me about them when I moved in 2 years ago. "Jack, what in the world is going on over here?" he called out. "HOA sent a crew to tear up my land without asking," I replied, the words sounding absurd even as I said them. "Said something about a beautification project." Tom's weathered face darkened. "Kimberly Anderson strikes again. That woman has been trying to expand the HOA's authority over every property in the area. You know your place isn't even technically in the HOA boundaries, right? That stopped me cold. What do you mean? When you bought this place, did you get any HOA disclosure documents? Tom asked. I thought back to the closing. No, nothing. My real estate agent said the property was outside the Meadowbrook Estates HOA jurisdiction. That's because it is, Tom confirmed. Your 5 acres and my 5 acres were both part of the original Henderson family ranch. My grandfather homesteaded this land in the 1920s. When the developers came in the 80s and built Meadowbrook Estates, they bought up a bunch of the surrounding land, but our parcels were specifically excluded. We're not members of that HOA, never have been. The implications of what Tom was saying hit me like a freight train. So they have absolutely no authority to be here at all. None whatsoever, Tom agreed. But Kimberly has been trying to force non-member properties into compliance with their rules for years. She's convinced that the whole area should fall under HOA control for property values or some nonsense. I have told her a dozen times to leave us alone, but she doesn't listen. A truck pulled up before I could respond, and a man in his 40s with a clipboard and a company polo shirt got out. He had the look of someone used to dealing with complaints and not caring much about them. I'm Derek Morrison, Site Supervisor for Rocky Mountain Land Services, he announced. What seems to be the problem here? The problem is, your crew is tearing up my private property without my permission, I said, walking over to meet him. I want them off my land immediately, and I want to know who authorized this work. Derek consulted his clipboard. We have a contract with Meadowbrook Estates HOA, signed by the president, Kimberly Anderson. The work order specifies clearing and leveling this lot for a community garden project. This is not HOA property, I explained, forcing myself to stay calm. This is my private land, and I am not a member of the HOA. You are trespassing. Derek frowned. The HOA provided us with a map showing all the properties included in the project. This address was clearly marked. I don't care what their map shows, I replied. I have a deed that says this is my property, and I am telling you that you do not have permission to be here. A Jefferson County Sheriff's deputy arrived at that moment, his cruiser pulling up next to Derek's truck. Deputy Mike Torres was someone I had met before at a community meeting, a solid guy who actually seemed to care about doing his job right. Morning, folks, he said, getting out of his car. Got a report of a property dispute. What's going on? I explained the entire situation while Derek tried to interrupt several times with his version. Deputy Torres listened to both of us, then asked to see my deed and Derek's work authorization. I pulled up the digital copy of my deed on my phone while Derek produced his paperwork. The deputy studied both documents carefully. Mr. Morrison, this deed clearly shows that Mr. Sullivan owns this property outright. Do you have any documentation showing that the HOA has an easement or any other legal right to authorize work here? Derek shuffled through his papers. Just the contract with the HOA and their map. They told us all the properties were cleared for work. That's not sufficient, Deputy Torres said. Mr. Sullivan is the property owner, and he is asking you to leave. If you continue working without his permission, you will be trespassing, and I will have to cite you. I suggest you contact the HOA and sort this out with them. We're going to lose a whole day's work, Derek protested. The contract specifies penalties for delays. That is between you and the HOA, the deputy replied, but you cannot work on private property without the owner's consent. Pack up your equipment and leave. Derek looked furious, but he nodded to his crew. All right. Edie, load it up. We're done here. As the workers began the process of getting their machinery onto the trailers, Deputy Torres took me aside. Mr. Sullivan, I would recommend you document all the damage thoroughly and consider getting an estimate for repairs. If the HOA authorized this work without proper authority, they could be liable. Already on it, I assured him. I have been taking photos and video since I realized what was happening. Good, he said. You might also want to talk to a property attorney. This kind of HOA overreach can get complicated, and you want to protect yourself. Tom had been standing nearby during all of this, and he chimed in. Jack, I know a good attorney who specializes in property disputes. Helped me a few years back when Kimberly tried to fine me for not maintaining my lawn to HOA standards. Want me to give him a call? Please, I said. I have a feeling this is just the beginning. The deputy took statements from everyone, including the crew members, and gave me a case number for my records. As the machines were finally loaded and driven away, I stood looking at the destruction they had left behind. A quarter-acre of ruined meadow, torn-up topsoil, and crushed plants. The financial damage alone would be substantial, but the loss of years of careful cultivation was even worse. Tom made his call, and within an hour, I was on the phone with Marcus Webb, an attorney who specialized in HOA disputes and property law. I explained the entire situation to him, and he listened without interrupting. "This is pretty egregious," Marcus said when I finished. "The HOA clearly overstepped their authority, and they will be liable for the damages. I would recommend we send them a formal demand letter immediately, documenting the trespass and property damage, and requesting immediate compensation." "How much are we talking about?" I asked. "I will need to see the full extent of the damage, but based on what you are describing, you are looking at several $1,000s minimum," Marcus replied. "The cost of restoring the native plantings, repairing the topsoil, and compensating you for loss of use during the restoration period. We should also include your time and the emotional distress this caused." "I also want them to admit they screwed up," I added. "I don't want them thinking they can do this to other people." "We can certainly push for that," Marcus agreed. "Can you meet me at your property tomorrow morning? I want to see the damage firsthand and take my own documentation." We arranged for him to come by at 9 the next morning. After hanging up, I spent the rest of the day documenting everything in excruciating detail. I measured the damaged area, cataloged every destroyed plant species I could identify, and took photos from every angle. I also wrote down everything that had happened, while it was still fresh in my mind. That evening, my phone rang. The caller ID showed a number I didn't recognize, but it had a local area code. "Hello? Is this Jack Sullivan?" a woman's voice asked. She had that particular tone that immediately set my teeth on edge, the one that suggested she was used to being in charge and did not appreciate being questioned. Speaking? This is Kimberly Anderson, president of the Meadowbrook Estates Homeowners Association. I understand there was an incident at your property today involving some contracted work." "An incident?" I repeated, anger flaring again. "You sent a crew to tear up my property without permission. That is trespassing and property damage, not an incident." "Now, let us not be dramatic," Kimberly said, her tone dripping with condescension. "There was clearly a miscommunication about which properties were included in our community improvement project. I am sure we can resolve this amicably." "There was no miscommunication," I shot back. "My property is not part of your HOA. I never gave anyone permission to do any work here. Your contractor caused significant damage to my land." "Well, according to our records, all properties in this area fall under HOA jurisdiction," Kimberly insisted. "Perhaps there is an error in your deed, or you were not properly informed when you purchased." I could not believe what I was hearing. "Are you seriously suggesting that your records are more accurate than my legal deed?" "I am saying that there seems to be some confusion, and we should sit down and discuss this like reasonable adults," Kimberly replied. "I am sure once you understand the benefits of being part of our community association, you will see that this project is in everyone's best interest." "I have zero interest in being part of your association," I said firmly. "What I want is for you to take responsibility for the damage your contractor caused and compensate me for the repairs." There was a pause on the other end of the line. When Kimberly spoke again, her voice had lost its fake friendly tone. "Mr. Sullivan, I would strongly encourage you to reconsider your attitude. The HOA has significant resources and legal support. Fighting us would be expensive and time-consuming for you. It would be much simpler to work with us." "Is that a threat?" I asked, my voice cold. "It is friendly advice," Kimberly replied. "I have been managing this HOA for 8 years, and I know how these situations play out. Homeowners who refuse to cooperate often find themselves facing fines, liens, and legal action that cost them far more than simply complying would have." "Good thing I am not a homeowner in your association then," I said. "And for your information, I have already documented all the damage and contacted an attorney. You will be hearing from him very soon." I hung up before she could respond. My hands were shaking again, but this time it was pure anger. The arrogance of that woman was breathtaking. She had basically admitted that the HOA routinely bullied people into compliance and was threatening to do the same to me. I called Marcus Webb back and told him about the conversation. He laughed, but it was not a happy sound. "That was incredibly stupid of her," he said. "She just admitted that the HOA authorized the work and she essentially threatened you. Document that call if you can remember the details." "I can do better than that," I replied. "Colorado's a one-party consent state for recording, right?" "It is," Marcus confirmed. "Did you record the call?" "No, but I will if she calls again," I said. "What should I do in the meantime?" "Write down everything she said while it is fresh in your mind," Marcus advised. "Be as detailed as possible. And if she contacts you again, record it. This kind of behavior from an HOA president is going to look very bad if we end up in court." That night, I barely slept. I kept thinking about the destroyed meadow, about Kimberly's threats, and about what might happen next. I'd bought this property specifically because it was outside HOA control. I'd spent 2 years making it my own, creating a small haven of native plants and wildlife. Now, some power-hungry HOA president thought she could just bulldoze it without consequences. Marcus arrived right on time the next morning, a Sunday. He was in his late 40s with graying hair and the no-nonsense demeanor of someone who had seen every trick in the book. He spent almost an hour examining the damaged area, taking his own photos and measurements, and making notes on a tablet. "This is bad," he said finally. "They destroyed what looks like a well-established native plant meadow. Do you have any documentation of what you planted and when?" "I have receipts for all the native seed mixes I bought, plus photos from over the past 2 years showing the progression," I told him. "I was documenting it for a blog I was thinking about starting on native landscaping." "Perfect," Marcus said. "That will help establish the value of what was destroyed. I'm going to consult with a landscape architect who specializes in native ecosystems to get a professional assessment of the damage and cost of restoration." Over the next few days, things moved quickly. Marcus sent a formal demand letter to the Meadowbrook Estates HOA, detailing the trespass, the property damage, and demanding compensation in the amount of $15,000. The figure was based on a preliminary assessment by the landscape architect, factoring in the cost of topsoil repair, replacement plantings, professional installation, and ongoing maintenance for the first year to ensure establishment. The HOA's response came 4 days later. Instead of an apology or an offer to settle, I received a certified letter informing me that I was in violation of HOA covenants for failing to maintain my property in accordance with community standards. They demanded that I remove several items from my property, including a small storage shed I had built, a vegetable garden that was visible from the road, and what they called an unapproved gravel driveway. I called Marcus immediately. "They are doubling down. This is insane." "It is also actionable," Marcus replied. "They are now engaging in harassment and attempting to enforce rules they have no authority to enforce. This actually works in our favor. Forward me that letter, and I will amend our demand to include harassment and legal fees." "Should I be worried?" I asked. "Can they actually put a lien on my property or something?" "No," Marcus assured me. "They have no legal standing to enforce anything on your property because you are not a member of the HOA. However, that doesn't mean they won't try to make your life difficult in other ways. Be prepared for them to escalate." He was right. Over the next week, I received 3 more certified letters from the HOA, each one threatening fines and legal action for various supposed violations. I also started getting complaints called into the county about supposed code violations on my property. Each one required a county inspector to come out, look around, and confirm that there were no actual violations. The county inspector, a tired-looking woman named Sarah Chen, apologized after her 3rd visit. "I'm sorry about this, Mr. Sullivan. It is pretty clear that someone is filing false complaints to harass you. I'm going to note in my reports that these are unfounded, and if we keep getting calls about your property, we may pursue charges for filing false reports." "It is the HOA," I told her. "They are mad that I won't let them push me around." Sarah sighed. "Yeah, I figured. Meadowbrook Estates, HOA, has a reputation for this kind of thing. We get complaints from them all the time about properties that aren't even in their jurisdiction. I wish I could say it will stop, but in my experience, it usually gets worse before it gets better." She was right about that, too. 2 weeks after the initial incident, I came home from work to find a notice posted on my front door. It was from the Jefferson County Planning Department informing me that a complaint had been filed claiming I was running an illegal business from my residential property. I had to appear at a hearing to address the allegation. I was furious. I called Marcus again, and he was equally angry. "This is beyond harassment now," he said. "This is abuse of process. We need to go on the offensive. I'm going to file a lawsuit against the HOA for trespassing, property damage, harassment, and intentional infliction of emotional distress. We will also seek an injunction preventing them from any further contact with you or any county officials regarding your property." "Do it," I said. "I am done playing nice." The lawsuit was filed the next day. Marcus told me that the HOA would be formally served within a few days, and then we would wait for their response. In the meantime, I had to deal with the county hearing about the alleged illegal business. I appeared at the hearing with Marcus, bringing documentation showing that I was employed full-time at a software company in Denver and did not run any business from my home. The hearing officer reviewed the complaint, which claimed I was operating a landscaping business based on the fact that I had landscaping equipment visible on my property. "Mr. Sullivan, do you own landscaping equipment?" the hearing officer asked. "Yes, I own a riding mower, a small tractor, and various hand tools," I confirmed. "I use them to maintain my 5-acre property. I do not provide any services to anyone else, and I do not run a business." The hearing officer looked at the person who had filed the complaint. It was Kimberly Anderson herself. She was exactly what I had imagined, a woman in her early 50s with an aggressive blonde bob haircut, wearing a business suit that probably cost more than my monthly mortgage payment, and an expression of absolute certainty that she was in the right. "Mrs. Anderson, what evidence do you have that Mr. Sullivan is running a business from his property?" the hearing officer asked. "He has commercial-grade equipment on his property, and his lawn is not maintained to residential standards," Kimberly replied. "In my professional opinion as HOA president, this indicates commercial activity." "Having equipment does not constitute running a business," the hearing officer said patiently. "Do you have evidence of customers coming and going, commercial vehicles, business signage, or anything else that would actually indicate a business operation?" Kimberly's face reddened. "I have observed vehicles on his property at various times." "Do you have evidence that these vehicles were customers rather than personal guests?" the hearing officer pressed. "Well, no, but then this complaint is unfounded," the hearing officer interrupted. "Mr. Sullivan, your hearing is concluded. There is no violation. Mrs. Anderson, filing false complaints is a serious matter. If we receive additional unfounded complaints from you regarding this property, we will pursue penalties. Do you understand?" Kimberly looked like she wanted to argue, but she nodded stiffly. As we left the hearing room, she caught up to me in the hallway. "This is not over," she hissed. "You think you can just sue the HOA and get away with it? We have insurance and lawyers on retainer. We will bury you in legal fees." Marcus stepped between us. "Mrs. Anderson, you are now directly threatening my client in front of witnesses. I would strongly advise you to stop talking and contact your attorney immediately because you are making this much worse for yourself." Kimberly glared at both of us, but stormed off without another word. As we walked to our cars, Marcus was shaking his head. "That woman is her own worst enemy," he said. "Every time she opens her mouth, she gives us more ammunition. This is going to be an easier case than I thought." The HOA's response to our lawsuit came 2 weeks later, and it was even more absurd than I expected. They denied all wrongdoing, claimed that the damaged property was actually HOA, common area that I had been illegally using, and filed a counterclaim against me for trespass, unauthorized use of HOA property, and demanding that I pay for the cost of the land clearing work they had done. "They are claiming my property is their common area?" I said to Marcus, incredulous. "How is that even possible?" "It is not," Marcus replied. "They are basically making things up at this point. But this counterclaim is going to cost them dearly. It shows they are acting in bad faith, and a judge is not going to look kindly on it. We filed a motion to dismiss their counterclaim, providing copies of my deed, the county property records, and Tom Henderson's sworn affidavit explaining the history of the property. We also filed a motion for summary judgment on our claims, arguing that the facts were not in dispute and we should win without even going to trial. The hearing for both motions was scheduled for late June, 3 months after the initial incident. In the meantime, the harassment continued. I received more violation letters from the HOA, more false complaints to the county, and even had someone from the HOA board show up at my workplace trying to serve me with what they claimed was a legal summons, but was actually just another HOA violation notice. That last incident resulted in Marcus filing an emergency motion for a restraining order against Kimberly Anderson and the HOA board, prohibiting them from contacting me except through legal counsel. The judge granted it immediately, warning the HOA that any further direct contact would result in contempt charges. Finally, the hearing date arrived. Marcus and I showed up at the Jefferson County Courthouse at 8 in the morning, ready for what we hoped would be the end of this nightmare. The HOA was represented by a law firm from Denver, and they had sent 2 attorneys who looked distinctly uncomfortable with the case they had been given. Judge Patricia Morrison was in her 60s, with a reputation for not tolerating nonsense in her courtroom. She reviewed the motions and the supporting documents before the hearing even started, and when she called the case, her expression suggested she had already made up her mind. "I have reviewed the pleadings and evidence submitted by both parties," Judge Morrison began. "Mr. Sullivan, your motion to dismiss the counterclaim is granted. The HOA has provided no credible evidence that the property in question is anything other than your private land. The deed is clear, the county records are clear, and the history presented by Mr. Henderson is convincing. The counterclaim is dismissed with prejudice." The HOA attorneys tried to object, but Judge Morrison cut them off. "Counsel, I am not interested in hearing arguments that contradict clear documentary evidence. Your clients filed a frivolous counterclaim, and they are going to pay for it. Now, let us move on to Mr. Sullivan's motion for summary judgment." For the next hour, the judge reviewed the evidence of the trespass and property damage. Marcus presented photos, the landscape architect's report, receipts for the original plantings, and documentation of all the harassment that had followed. The HOA's attorneys tried to argue that it was an honest mistake and that the HOA should not be held liable for the contractor's actions. Judge Morrison was having none of it. The HOA authorized the work, the HOA provided the map directing the contractor to Mr. Sullivan's property, and the HOA president personally approved the job. The HOA is absolutely liable for the resulting damage. Furthermore, the pattern of harassment documented here is deeply concerning. An HOA has no authority to enforce rules on non-member properties, and attempting to do so through false complaints and threats is unacceptable. She granted our motion for summary judgment, awarding us the full $15,000 in damages plus attorney fees. She also issued an injunction prohibiting the HOA from any further attempts to enforce rules on my property or file complaints with county officials regarding my property without credible evidence of actual violations. "If the HOA violates this injunction, I will hold the board members personally in contempt," Judge Morrison warned. "This court takes abuse of process very seriously. Do your clients understand that, counsel?" The HOA attorneys nodded, looking miserable. As we left the courtroom, Marcus was grinning. "That went even better than I hoped," he said. $15,000 in damages plus attorney fees, which are going to be substantial. And the injunction means they can't harass you anymore without facing criminal contempt charges." "Is it really over?" I asked, almost afraid to believe it. "For the most part," Marcus said. "They have 30 days to pay the judgment. If they don't, we can start collection proceedings, which could include liens on HOA assets. But with a court order this clear, I expect they will pay." I felt like a weight had been lifted off my shoulders. 3 months of stress, harassment, and constant worry were finally over, or so I thought. 2 weeks later, I received a check from the HOA for $15,000, along with a terse letter from their attorney stating that payment was being made under protest. Marcus advised me to cash it immediately, which I did. The attorney fees, which came to another $12,000, arrived a week after that. But Kimberly Anderson was not done. Even though the injunction prohibited direct contact, she found ways to make her displeasure known. She spread rumors in the community that I was a difficult neighbor who had sued the HOA over trivial matters. She told people I was trying to destroy property values in the area. She even contacted my employer, claiming I had threatened her and asking if the company knew they employed someone so aggressive. That last move was a serious mistake. My employer, a tech company with a robust legal department, did not appreciate being dragged into a personal dispute. They contacted Marcus, who contacted Kimberly's attorney, who apparently read her the riot act because the harassment suddenly stopped. For a few weeks, everything was quiet. I used the settlement money to hire the landscape architect and a restoration crew to repair the damaged meadow. They brought in new topsoil, carefully selected native plant plugs that matched what had been there before, and set up an irrigation system to help everything get established. It was not going to be exactly the same as what I had created over 2 years, but it was a good start. Tom Henderson came over one evening as I was inspecting the restoration work. He brought a 6-pack of local beer, and we sat on my porch watching the sunset. "I heard you won in court," Tom said. "Good for you. Someone needed to stand up to that woman." "It was exhausting," I admitted. "I never wanted to be in a legal fight. I just wanted to be left alone on my own property." "That's all any of us want," Tom agreed. "But people like Kimberly, they can't help themselves. They need to control everything and everyone around them. The HOA presidency gives them a little bit of power, and they abuse it." "Is she going to stay president?" I asked. "After all this?" Tom shrugged. "Probably. The people who are actually in the HOA mostly just want their streets plowed and their common areas maintained. They don't pay attention to what the board does unless it affects them directly. Kimberly runs unopposed every year because nobody else wants the job." "That is depressing," I said. "It is reality," Tom replied. "But at least now she knows she can't mess with properties outside her jurisdiction. You set a precedent. If she tries this with anyone else, they can point to your case." We drank our beers and watched the sun go down behind the mountains. The restored meadow was just starting to green up, and I felt a sense of hope that things might actually work out. Then, about a month after the court judgment, things took an unexpected turn. I got a call from Deputy Torres, the same sheriff's deputy who had responded to the initial incident. "Mr. Sullivan, I wanted to give you a heads up about something," he said. "We have been investigating some irregularities with the Meadowbrook Estates HOA, and your case came up as part of that investigation." "What kind of irregularities?" I asked. "Dikah? I can't go into details yet, but it involves potential financial mismanagement and fraud," Deputy Torres explained. "There are several homeowners who have filed complaints alleging that HOA funds were misappropriated. Your lawsuit and the settlement payment actually helped trigger a deeper look into their finances." "Is Kimberly Anderson involved?" I asked, though I already knew the answer. "She is the focus of the investigation," Deputy Torres confirmed. "Again, I can't say more right now, but I wanted you to know in case you were contacted as part of the investigation." Sure enough, a week later, I received a call from an investigator with the Colorado Attorney General's office. They were investigating allegations of HOA fraud and wanted to ask me some questions about my interactions with Kimberly Anderson and the Meadowbrook Estates Board. I met with the investigator, a serious woman named Rebecca Hoffman, at a coffee shop in Lakewood. She recorded our conversation as I walked her through everything that had happened, from the initial trespass to the harassment to the final court judgment. She took extensive notes and asked detailed questions about Kimberly's behavior and statements. "What you are describing fits a pattern we have seen with several other complainants," Rebecca told me. "Mrs. Anderson appears to have been using HOA funds for unauthorized purposes, including personal expenses. She also apparently hired contractors for work that was never properly approved by the board and pocketed some of the money that was supposed to pay for those services." "So the crew that destroyed my property," I said slowly, "was that one of those deals?" "We believe so," Rebecca confirmed. "According to the contractor you dealt with, Rocky Mountain Land Services, they were only paid about 60% of what the HOA had budgeted for that job. The rest seems to have disappeared." "Is she going to be charged?" I asked. "That is up to the district attorney, but based on what we have found so far, criminal charges are likely," Rebecca said. "Fraud, embezzlement, possibly theft. It depends on how much evidence we can gather." Over the next few months, the investigation continued. I heard through Tom and other neighbors that the HOA had brought in a forensic accountant who discovered years of financial irregularities. Kimberly had apparently been siphoning off funds through fake vendor invoices, inflated service contracts, and unauthorized personal expenses charged to the HOA. The whole scheme started to unravel when homeowners noticed that their dues kept going up while the quality of services kept going down. They started asking questions, requesting financial records, and eventually hired their own attorney to investigate. My lawsuit had added another layer of scrutiny because it forced the HOA to pay out a significant judgment, which left them unable to pay for other planned projects. That got more homeowners asking questions about where the money was actually going. In September, 6 months after the crew had torn up my property, Kimberly Anderson was arrested and charged with multiple counts of fraud, embezzlement, and theft. The charges covered over $200,000 in misappropriated HOA funds over a 5-year period. The news made the local papers, and I received calls from several reporters asking about my experience with her and the HOA. I gave a couple of interviews, carefully sticking to the facts of my case and avoiding speculation about the criminal charges. Marcus advised me to be cautious about what I said publicly, since Kimberly was entitled to a presumption of innocence until convicted. The criminal case moved slowly through the system. Kimberly hired an expensive defense attorney and initially pled not guilty to all charges. But as the prosecution presented its evidence at the preliminary hearing, the case against her became overwhelming. The forensic accountant testified about the missing funds, contractors testified about invoices that did not match work performed, and board members testified that Kimberly had kept them in the dark about the HOA's true financial situation. In December, Kimberly changed her plea to guilty in exchange for the prosecution dropping some of the lesser charges. She was convicted of multiple felony counts of embezzlement and fraud. In February of the following year, she was sentenced to 3 years in state prison and ordered to pay full restitution of the stolen funds. I attended the sentencing hearing, sitting in the back of the courtroom. Kimberly looked like a different person from the aggressive, confident woman who had threatened me over the phone nearly a year earlier. She was pale and drawn, and she cried as the judge pronounced sentence. Mrs. Anderson, you held a position of trust within your community," Judge Harold Chen said at sentencing. "The homeowners who elected you as HOA president trusted you to manage their funds responsibly and act in their best interests. Instead, you betrayed that trust repeatedly over many years, stealing money that was meant for community improvements and using it for your own benefit. Your actions have caused real harm to real people, including Mr. Sullivan, whose property you damaged in your capacity as HOA president. The sentence of this court reflects both the seriousness of your crimes and the need to deter others who might be tempted to abuse similar positions of authority." After the hearing, several homeowners from Meadowbrook Estates approached me in the hallway. They apologized for what had happened and thanked me for standing up to Kimberly. One woman told me that if I had not fought back and forced the public scrutiny, they might never have discovered the embezzlement. "You did our whole community a service," she said. "I know it cost you time and stress, but you exposed someone who was stealing from all of us." It was a strange feeling, being thanked for something that had started as just trying to protect my own property. But I appreciated the sentiment. The Meadowbrook Estates HOA underwent significant changes after Kimberly's arrest. The entire board was replaced, new financial controls were put in place, and they hired a professional management company to handle day-to-day operations. The new board president reached out to me with a formal apology and an assurance that the HOA would never again attempt to exercise authority over non-member properties. My property continued to heal. The restored meadow grew and beautifully that summer, and while it was not exactly the same as what I had created originally, it was close. The native plants flourished, attracting butterflies and birds and creating the kind of natural ecosystem I had wanted. Tom and I became good friends, often sharing beers on one of our porches and talking about everything from politics to gardening to the best hiking trails in Jefferson County. He told me stories about the old days before the HOA existed, when the area was still mostly ranch land and everyone knew their neighbors. "You know what the real lesson here is?" Tom said one evening, about a year after everything started. "Power corrupts, especially small power over small things. An HOA presidency doesn't sound like much, but to someone like Kimberly, it was enough authority to make her think she could do whatever she wanted. She lost sight of the fact that she was supposed to be serving her community, not ruling over it. "Do you think HOAs are all bad?" I asked. "No, not all of them," Tom said thoughtfully. "Some are run well by people who genuinely want to maintain property values and keep neighborhoods nice, but they attract a certain type of person, the kind who likes being in charge and telling others what to do. And without proper oversight and accountability, they can turn toxic fast." I had to agree with that assessment. My experience had taught me to be very careful about any organization that had power over where and how I lived. I was grateful that my property was outside the HOA's jurisdiction, and I made sure to stay involved in local government to ensure it stayed that way. The financial restitution from Kimberly's criminal case took years to collect since she had already spent most of the stolen money. The HOA received some of it back, and they were eventually able to complete the community projects that had been delayed by the missing funds. I kept the $15,000 from my civil judgment, of course, since that was separate from the criminal restitution. I used some of that money to build a proper fence around my property line, just to make absolutely clear where the boundaries were. I also installed security cameras covering my driveway and the areas most visible from the road, just in case any future HOA decided to try something similar. Tom did the same with his property. "An ounce of prevention," he said as we watched his fence being installed. Life eventually returned to normal. I went to work, maintained my property, hiked in the mountains on weekends, and generally enjoyed the peace and quiet of rural Colorado living. The Meadowbrook Estates, HOA, left me alone, and I left them alone. But the experience changed me in some important ways. I became more aware of property rights issues and more willing to speak up when I saw injustice. I joined a local property rights advocacy group and even testified before the county commission a couple of times on issues affecting rural landowners. I also developed a much lower tolerance for bullies and bureaucratic overreach. When I saw people being pushed around by organizations or individuals with a little bit of authority, I was more likely to step in and say something. Marcus Webb joked that I had become a professional thorn in the side of petty tyrants. "That is not a bad thing to be," he said with a grin. Looking back on everything that happened, from that first morning when I heard heavy machinery tearing up my meadow to Kimberly Anderson being led away in handcuffs, I realized that standing up for myself had been worth it. It would have been easier to just let it go, to accept the damage and move on. A lot of people probably would have done that, but letting it go would have meant letting Kimberly continue her pattern of abuse and theft. It would have meant sending the message that people could violate property rights without consequences, and it would have meant giving up my right to control what happened on my own land. The legal fight was stressful and expensive, even though I ultimately recovered my costs. The harassment was infuriating and sometimes scary, but in the end, justice was served. My property was restored, the HOA was reformed, and a criminal was held accountable for her actions. I still live on my 5 acres in Jefferson County. The meadow is thriving now, better than ever. Native grasses wave in the breeze, wildflowers bloom from spring through fall, and I regularly see deer, rabbits, and even the occasional fox passing through. It is exactly what I wanted when I bought the place. Tom is still my neighbor and friend. We have added several other neighbors to our unofficial Rural Landowners Alliance, people who live just outside the HOA boundaries and want to make sure their property rights are protected. We keep an eye on local government actions, attend relevant meetings, and support each other when issues come up. The new Meadowbrook Estates HOA board is competent and respectful. They focus on maintaining the common areas within their actual jurisdiction and have stopped trying to extend their authority beyond it. They learned an expensive lesson about accountability and legal boundaries. As for Kimberly Anderson, she served her prison time and was released in early 2029. I heard through the grapevine that she moved out of state after her release, probably wanting to start over somewhere her reputation had not preceded her. I do not wish her ill, but I'm glad she is far away from here. Every time I look at my restored meadow, I think about that morning when the bulldozer showed up. I think about how angry and violated I felt, watching years of work being destroyed in minutes, and I think about the choice I made to fight back instead of accepting it. It was the right choice, not just for me, but for my community and for everyone who believes that property rights mean something. The law is not just words on paper. It is only real when people are willing to stand up and enforce it, even when it is difficult and expensive and stressful. I learned that HOAs can be dangerous when they are run by the wrong people, that small-scale corruption is still corruption, and that speaking truth to power matters even when that power is relatively small. I also learned that there are good people willing to help when you stand up for what is right, from attorneys like Marcus Webb, to law enforcement officers like Deputy Torres, to neighbors like Tom Henderson. The whole experience made me a better citizen, a better neighbor, and a more engaged member of my community. It taught me to pay attention to local government, to read the fine print, to document everything, and to never assume that people in authority are acting in good faith just because they hold a title. Most importantly, it taught me that my property, my home, and my rights are worth fighting for. Nobody has the right to tear up your land without permission, no matter what organization they represent or what authority they claim to have. Property rights are fundamental to freedom, and defending them is not just about protecting your own interests. It is about maintaining a society where individual rights are respected and the rule of law actually means something. So yes, the HOA sent a crew to plow my land without asking. I billed them for trespassing and property damage, and when they tried to bully me into backing down, I took them to court and won. The HOA president went to prison for her crimes, my property was restored, and I kept my rights intact. It was not easy, but it was worth it. Every single day when I walk out onto my porch and see that meadow full of native plants and wildlife, I know it was worth it. This is my land, my home, and nobody gets to take that away from me without a fight.